We're back with the Tech Policy Grind. I'm Rima Musa, and I'm a fellow with the Internet Law and Policy Foundry, the organization where the next generation of tech law and policy professionals convene to write, think, and talk about the web, technology, and disruptive innovation. This is the Tech Policy Grind, the Foundry's podcast where we chat about what's going on in the world of tech policy. Hi everyone, welcome back to the Tech Policy Grind. Coming to you live from Medellin, Colombia, because why not? For this week's episode, we have another iteration in our hackathon series. If you haven't been following along, the theme for this year's policy hackathon is artificial intelligence, because of course it is. Today's episode features excerpts from our latest webinar on the intersections of AI and intellectual property, led by Foundry Fellow Ekene Chukwuokeke. She sits down with Franklin Graves, Technology Counsel at HCA Healthcare, Elena Gurevich of the Center for Art Law, and Ju-Yoon Han of NYU Law's Engelberg Center on Innovation Law and Policy, and a partner at Eisenberg and Baum LLP in New York City. They get into copyright law's protections in the era of generative AI and its complications, how artists can contribute to the conversation, and what the U.S. Copyright Office is doing about it. Spoiler, there's some guidance out there, folks. Enjoy.
Hello, everyone. My name is Ekene Chukwuokeke, and I'm a fellow with the Internet Law and Policy Foundry. So to begin with, IP and AI are very broad terms. We had an introductory AI 101 series 2 weeks ago, but for the purpose of our conversation today, what is AI? Can we simply explain what it is and what specifically we're talking about today? Franklin?
Yeah, artificial intelligence means a lot of different things. Simplistically, artificial intelligence is a concept that is attempting to have a machine or a computer mimic what a human can do from a thought process or from an action standpoint.
Thank you. So today we're going to specifically talking about generative AI, which is a subset of AI. How do generative AI tools function?
These models, they identify patterns within the existing data that's been fed into them. Then the models are using these patterns to generate new and original content, which sometimes can be infringing on other people's copyright, because obviously all the data that's been scraped from off of the internet is not in public domain.
So at this point, I would then ask, what is copyright? What is IP?
So IP basically refers to creations of the mind, right? Artistic, literary works, inventions, symbols, anything and everything that kind of people are coming up with their creative output, so to speak. It protects the original works of authorship. A song or a painting or any piece of creative and original work created by humans.
Human created work. Okay. We're going to get back to that soon. So we've defined IP, we've defined copyright and also AI. So what does copyright law, which has been around forever, have to do with this seemingly new phenomenon of, generative AI?
If I may just kind of jump in, copyright as of now, as the Copyright Registration Office has opined, it's only going to protect the rights of human-derived, human-created artworks. And that is very important because when we talk about rights and intellectual property, a property right is something that belongs to somebody, right? And there is a person who can exercise that right. If there's no person that can exercise that right is futile, right? It's meaningless if you can't exercise it. Although, there is a program that's made by a human being, there is a art that's not made by a human being. And so there is this great gap where, litigation is now coming to bear. And courts are trying to figure out what to do with that right and who owns that right.
So is it legal? Because I think ChatGPT pretty much scraped most of the available information on the internet. So is this legal for them to just use available content on the internet for free? Is this legal? Is it illegal?
If you're talking about web scraping to build a database or to compile a database, then it begs this question of, are you exceeding the permitted access to a website by going to a website for purposes of extracting the information, the content from that website. And so currently there are a slew of laws that could trigger this, whether it's the CFAA, the Computer Fraud and Abuse Act, or whether it is the terms and conditions that are on the website, or something even on the technical side, if there's a robot.txt, or if there's some other technical mechanism that is put in place, whether it is a login or some other type of firm wall that prevents or intended to prevent somebody not exceeding the scope of their authorization on the website to take information from the website. There's a whole host of scenarios and questions that raise legal issues. But then additionally, outside of the context of just access and the right to access publicly available content, then it begs the question of, okay, then even if you can access that publicly available content, is it still subject to usage rights under copyright law? So just because you can access something doesn't necessarily mean that it's still not subject to copyright.
So web scraping itself is not technically illegal, but it could still violate other laws potentially, including copyrights. I know that there was the Google Books case a while ago where Google was sued because they were they were scanning books that were publicly available, books that are available on the internet, to make them publicly available as Google Books, to make excerpts of them available. And Google was able to rely on the fair use defense in that case. I think the court found their use transformative. So do you think that today in 2023, with what companies like ChatGPT are doing, do you think there's a good chance they'll be able to rely on the Google Books defense, like fair use, like Google Books did, or is it kind of different?
I think the Google Books issue and possibly the potential ChatGPT issue about fair use is something that's going to be really stretched. Fair use doctrine is a very fact-specific issue. And so naturally, it'll be like a case-by-case scenario where courts are going to have to sit down and decide. And I'm not sure that we have the, shame on me, but I'm not sure that court systems are ready to handle millions of these cases and look at, okay, does this look like the computer copied this work or not, right?
And I would just add, I think there's not very many artists that can be out there and pinpoint exactly this is proof that my particular work was part of the training data that informed this output. But I think we're seeing in the Getty image case against OpenAI, there are artifacts that override, that are so prominent in the training material that it's like a watermark, like the Getty image watermark, that it's going to pop up and crop up in those types of images if certain triggers are met.
I also just kind of quickly wanted to add to Jae-Young's point about the plaintiffs and the hurdles that they're facing, right, when it comes to generative AI infringement litigation. So it's not even like the legal hurdles, but technical hurdles as well. For example, right, the artist wants the platform to take down her artwork. For example, she is convinced that her artwork, the model was trained on the artwork, right? And there's no, as far as I know, and I've read quite a bit of research on that, there's no way it can be done as of today. I mean, you will have to retrain the model.
But I think an important thing also to recognize is some services are implementing technical measures to prevent an output from being, to use a copyright term, substantially similar to any of the training materials. And so that is one practical implementation we're seeing to alleviate some of the concerns and reduce the risk.
Thanks, guys. And now I think it would be a good time to talk about the models themselves. In the case against Stable Diffusion, brought by Sarah Anderson and a number of other artists, they're making the argument that these models are being trained on a lot of data, and then they kind of like think back to that and they can just copy or create like a collage. So they're trying to make this argument that this machine has this endless memory, and then it makes like a collage of sorts, to create the new art. But then on the other hand, for people on the Stable Diffusion side, people are saying, well, that's not how the machine works, right? The machine isn't necessarily going to pick this element and that element. It's more like the machine has been taught how to think and it is thinking. So the machine isn't copying from memory. It's really just thinking like someone that has been trained, right, in a certain art. So just from your experience, like with litigation, observation of these cases, obviously we can't speculate and say we know what's going to happen, but how much of this is going to be decided based on the operation of the tech itself? Like, are the courts going to look at how does this machine work and try to apply the law to that? Or they'll be considering the other public policy reasons that you've already mentioned, which is the fact that it will be really, really hard to undo the system or to retrain these models because they've already been trained.
I think you're asking the court, look, we created this machine that's going to think on its own. And then whatever is observed is going to be interpreted as some new sort of inspiration for the machine. And how is that, ever a copying work, right? If we set that standard so high and we apply it to humans, then, the policy that you're referring to, which is it's going to stifle humans from creating any art. Because, if we think about it, like if I were to draw something of this, this apparatus that I have here, and I drew it, I can claim copyright, right? And it doesn't have to be like, I interpreted this object into like some super fashionable work. It doesn't take a lot for a right to be copyrighted at the moment. But if we're imposing a super high standard on machines, then that is a problem for stifling creativity issues, right? I'm very curious to know what would come out of such argument.
Elena, you mentioned this earlier that the Copyright Office said has come out to say that for copyright to be in a work to be protected, like a property right also, as Julian explained earlier, like it has to be held by a human being. But then what happens when generative AI output infringes, right? So who do we think should be held responsible if, a human being prompted the creation of that, but then they don't actually own the property right in that infringing work?
So when it comes to the outputs, right? The question is who owns them, and that might depend on the platform, right? The person is using, and you have to look to the terms of conditions of the platform. Some platforms are freely granting all the rights in the output to the users, and in that case, the work is yours. You can do whatever you want with it, and sort of the platform is just transferring all the liability from them to the user. Some platforms are not doing this, and again, it's gonna depend on it's a case by case basis, I would say as well. But the U.S. Copyright Office and everybody here is aware of this. Obviously, it has been one of the main driving forces of kind of just making things a little bit more clear for us all where the generative AI and copyright law stand on it. And it's been very helpful, kind of let's make the waters less muddied, I would say, right? And so where the U.S. Copyright Office stands as of today is the works that were generated by AI are not to be copyrighted on their own, right? And I'm referring obviously to Chris Kashtanov's case. So in the case of Chris Kashtanova, they created the work called Zarya of the Dawn. It's a graphic novel, and they used generative AI to create the images, and they filed the work to be they filed for copyright registration to the U.S. Copyright Office. And in the beginning, the work was registered and given copyright. But when the U.S. Copyright Office became aware of the fact that the images were AI generated, they canceled the registration, and then they issued their guidance on that, saying in the end the U.S. Copyright Office registered the novel as a whole, right, and the arrangement of the images in the work, but not the images themselves. Like the image that was AI generated cannot be copyrighted by itself. on its own, right? Only the compilation of images. So, and that's kind of just where we stand today. If I use DALL-E or Stable Diffusion to generate an image, and I go to US Copyright Office and be like, let's do this, let's register, and they won't be giving me any copyright in that. So anybody will be free to use my work because there was not sufficient original and creative input from me as a human being, according to the US Copyright Office. So where we stand today. I mean, in my opinion, might not be a very popular one, but I think like if an input, like if the prompt would be creative and sufficient enough, long enough, kind of just you've been thinking so much about this, and just it kind of just captures everything, whatever you had in your head, like your idea of the image you want to see. I think it could be copyrighted. The output of that. So, but again, I'm not the U.S. Copyright Office, so I can't speak for them. But the fun fact, and everybody is aware again of that, probably that the U.S. Copyright Office mentioned that while the images can be copyright, but the prompt itself might be. So again, they are not aware that any prompt were kind of just somebody who filed for U.S. Copyright registration for a prompt, but maybe somebody should, and we'll see where it's going to go. We need more cases like that. We need more people kind of just barging in and filing their work and just kind of, bringing some fresh ideas and fresh conversations into this. So I think it's very important.
And I would probably push back a little bit and disagree to an extent.
Please.
In terms of that question of the human authorship element, because yes, I certainly agree with the fact that prompt engineering, that whole process of learning how a tool or a system works is to a degree, there's a level of artistic or technical skill required. And so the Copyright Office, like we just said yesterday on a call, did acknowledge that. And although they're not aware of a use case right now or a submission for registration of a prompt, theoretically, it could be subject to copyright protection for the prompt itself. But I think one of the bigger issues that I'm still seeing is the lack of control, kind of like what we've been talking about up until this point, the lack of control over the AI tool or the system of tools that combine together power a generative AI tool. There's missing that ability to really understand how the output is going to work and what you're going to get on the other side. And so that's where like examples of like the Raya of the Dawn with Chris is they used the prompt included the name of Zendaya, an actress, and it was because of the fact of in order to get an output that maintained the same look of a character consistently enough to have different panes or have different images, you have to have some reference. Otherwise, you have no control over the tool. And I think that that's the same case in some of the newer registrations that are being pursued as well. And that's what the Copyright Office has been telling us is, from their standpoint, you lose that human creation, that human authorship in the process along the way of using a tool like that, because you give that up. You're then passing that on to a machine. And again, that's very specific to certain types of text, image, or prompt-based machines, but that's kind of the alternate take, I would say, on it.
Ekene, I just wanted to put a point out there. I think what Franklin says is very informative in terms of the ability to control. Right now, the ability to control doesn't belong to the regulators. It doesn't belong to the owners of the copyrighted artwork. So perhaps creating a new kind of art market, that is based upon this principle of AI generated art. And I think that's where control could come in, because there are consumers that drive the market and thus control what the supply and demand is. And that's how, in some ways, the pricing and the value of artworks will come forth. And the value is essential to determining what is a property right, because we can say intellectual property, I own this thing, but if it if the public doesn't see any value to it, right? Whatever I generated from the machine, then I'm going to be ending up with zero money, right? And so the value of a right is also very interconnected with what the art market demands. And what the art market demands is actually something that can be controlled by individual consumers and art aficionados and collectors and such and such. In doing that, though, in order to hijack, a piece of artwork and make that more valuable than others, I think marketing tools come in, right? And when we say, look, here is a jug, that emulates Picasso, it doesn't at all. But if I were to market it in that way, then I necessarily have to reference somebody that is of value, an artist that is of value. Even in a machine learning process, I have to say, hey, this artwork, I put it into the machine and it's like a Rembrandt, right? And then that might give it superiority in the market. But doing that kind of gives more of an anchor to say, hey, you marketed this and you use something as a reference. So maybe it's in the marketing tools that we can also look to when we look at infringement, not just about copyright, but it can be a consumer protection issue. That's where they value whether a machine-based art is going to be of something that we consider valuable as a property right or not.
I just, again, quickly wanted to add, I totally agree. The U.S. copyright law is sort of notoriously market driven, right? It tends to more protect artists' economic rights versus in the EU, right? And the UK, it's more on the moral rights side.
Thank you. So which will bring me to the next question, which is, so how are artists, we've already alluded to this a bit, but how are artists responding? How are companies adapting to the in-between place we are right now? So we don't have any decisions just yet resolving these pertinent issues. So how are artists responding, and how are these companies as well adjusting their stance to accommodate people's concerns?
On the one hand, I think artists are glad that there are tools that alleviate some of their labor, when it comes to generating artwork, when it also comes to generating like animation from one piece of art. I mean, that can take a tremendous amount of resources and manpower if you were to do it traditionally just by hand. But now that, there are ways to generate this, it could be of a way to alleviate the labor of artists. But at the same time, that means that if you're using AI tools just as tools, not in and of itself an artwork, it's something that I think artists are adapting to quickly and kind of welcoming as a tool. But when it comes to that, replacing the originality of the artist's own artworks, I think there's sufficient pushback about it. I'd be very interested to hear more from the ground if anyone has opinions about that as an artist or as a creator.
I just want to say, sometimes I have this habit of kind of just diving deep into Discord and Reddit and just kind of, feeling, like you said, the ground, talking to artists, kind of just subtly polling people. So what's your take on this and that? And
web scraping, Elena?
Huh?
You're web scraping for opinions?
I would call it more like intellectual poaching. But yeah, the artist community has been just formed by that. I would say people are so vastly polarized on this subject, and it's been very, very sort of interesting to see that people are clashing over that. Some artists are embracing the AI and they are just kind of just immersed in that, and they're using that for their work every day. But on the different side, the artists are totally anti-AI, and they're like, just let's ban the AI just altogether and just we'll be better off, And obviously the artistic communities, I would say, snobbish take on themselves, right? So like anyone who is not skilled enough to be an artist, to be called himself an artist, cannot call himself an AI artist. They calling these people AI users, sort of like you didn't do enough to kind of cross this line to be called an artist. So, which is like very, very interesting, if you ask me. So the sentiment essentially is, on the one side, is just let's do it. It's gonna make our work easier. Some of the artists are very, very confident they'll be keeping their jobs, because still what clients are going for is sort of their creative ideas, right? Some artists are saying, so when the client comes to me, the only thing they have is just like a name of a project. That's it. And when they come to me, I work with them together. We work collaboratively on the project. So from that word, the name of the project, kind of like everything grows. The images, the design, the concept, right? And the argument there is the AI can't do that. So usually when I'm about to use DALL-E or Stable Diffusion or any other platform, right, I already have an idea in my head. I already have a prompt. I already have something in my head that's just will generate an output, an image. I already sort of have this preconceived notion of something. But the argument on their side is, my clients come here, they have this name, they have nothing. They want me to kind of help them to be creative. So, and that's what AI is not capable of doing at the moment. The other side is just, let's ban it altogether. We are better off of it. And the funny thing is, a lot of the people, just judging by the comments, they're not even aware of how this technology works. Some people are like, let's ban AI. We don't need AI at all. Let's use YouTube. I like YouTube. I like how it works. But YouTube uses literally AI every day, like the algorithms, right? So what videos you would like to watch, they're analyzing and they're doing this, they're doing that. AI has been involved in our lives for a very long period of time, which is funny because most of the people are not aware of that. So again, I think education is important on that matter, and critical thinking is more important than ever today. So it's just, it's been a very, very interesting debate on there.
And I would caution, from my standpoint, I would caution against kind of this concept. I think what was mentioned earlier about the labor involved. I think that it's this concept of fast tracking the creation process, and that's something I think that we've dealt with as creatives for decades, for hundreds of years. There are always new tools, there are always new methodologies that can be used to create something. And so, like, to borrow from like copyright, it's like the sweat of the brow theory. Is there sufficient effort involved? And I think that can change from use case to use case. And so, for example, on when we made a switch and computer animation came about, arguably it's easier because you're not having to frame by frame paint or draw a character's movements. But in reality, there's a swap there of what the work involved is. It's the model creation, it's the programming that goes into it, the mathematics involved, and all the physics and all that. And another example is like Adobe Character Animator. If you have a puppet, you can put a puppet in Adobe Character Animator and use your webcam, and it will do facial recognition and body recognition to animate the character for you. That's what a lot of virtual YouTubers or VTubers use for their avatars. It's this question of, okay, well, are we looking at it from a human labor standpoint, or are we looking at it from the creativity behind how these tools are used and how they're implemented? And then the other distinction here too is, I think from what I'm seeing, is the ethics behind it. I think there's a big call for artists, or from artists to other artists, and artists to big companies, tech companies, and outside of the tech sphere, just general companies, to ethically and sustainably source the training materials in a way that, if the use case is going to be to have a generative AI tool that competes with those artists, making sure they're fairly compensated. If it's something that's like on the security side, if it's a model being developed to train and have security footage automatically reviewed to identify harmful objects or something like that, does that really compete with an artist who or a photographer, and the output that might be very similar and supplement a license for their work if somebody's using that to generate an image for their website, and instead of using a stock photography company, that's a missed license. So I think the use case really comes about in connection with how the training materials are gathered and whether there is appropriate payment or permission of some kind from the artist. So that's kind of what I'm saying. But I think in reality, I think we're moving to a place where it's going to be impossible to not have access to these tools, whether it's Microsoft and Google putting them in everything from Office 365 or Microsoft 365 online and all that.
Thank you, guys. And I will just give you the opportunity to leave your final closing remarks. One thing people should take away from this conversation about IP and AI.
I'll go first, I guess. So my takeaway would be there's been a tremendous surge in the interest about AI, right? There's been the hot topics for months, and people, for the most part, at least the people I've interacted with, for the most part, they tend to, I would say, think of the AI as this existential threat, right? To the point they make it almost sentient, right? And I think that's a very, very bad approach. And we need to stay focused. We need to remember that we have the agency. AI is just still, as of today, we'll talk about it in a month. Maybe things will change. It's just a tool. And there's no way the robots are taking over and all that fun stuff, fun Hollywood stuff. So we need to be just active in the space. People need to educate themselves. People need to talk to other people who know about this stuff, and just you have to be very, very thoughtful about it, because literally hundreds of new AI models and just startups are emerging every week. New tools are being deployed every day, like tens of them, hundreds of them every week. So, and it's very, very, very important for people not to rush into that. Just people tend to kind of just, jump into that without giving it a second thought. But there will always be privacy concerns, right? Personal information, some sensitive information if it's a corporation or a business. So people need to be very, 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 very thoughtful when they adopt these technologies in their everyday lives and their work life, especially.
Yeah, I would say my takeaway builds upon what was just said. Education is, of course, a very important component of all of this, making sure that you're educated, people listening, I myself, like she said, like Elena just said, like next month, there's going to be something new. We have to learn it. I have to learn about it, dissect it. I would add to that, now is a time that policy is being crafted on this. We have the EU AI Act that's underway, but especially in the US, like the Copyright Office just had listening sessions. There's opportunities with the USPTO on the patent and trademark side to give feedback. Voice your opinions, write about it, submit your questions or concerns to the Copyright Office or the Patent and Trademark Office. They want to listen. Your local Congress people, they want to listen. You have a voice, and I would just want to encourage people to use it. But just again, as we've been talking about, making sure that you're coming at it from an educated perspective, but also sharing your unique perspective. We all have our own use cases. We all have our own backgrounds and kind of understandings of how this technology impacts us individually, or the companies that we work for, or that we own, or that we run ourselves. So that's my takeaway is now is the time to voice your opinion. Now is the time to get out there and submit comments.
Thank you, guys. And my takeaway from all your brilliant submissions is that copyright could have an impact on the way generative AI system works and the output of them, but then it's not the only thing, right? We have to think about, we have a lot of power. The art market has a lot of power in determining the value of these works, and there are just other factors at play beyond copyright. So as Franklin said, we should all be educated and make our voices heard. So thank you everyone for joining us today. Really appreciate it. Bye.
Thank you, guys.
Thanks for moderating.
Bye.
Thanks for tuning into this episode of the Tech Policy Grind. If
If you enjoyed the show, get in touch with us at Foundry Podcasts with an S at ilpfoundry.us, or leave us a review wherever you're tuning in. I'm Rima Musa, the host of the show, and this podcast wouldn't be possible without the help of our team at the Internet Law and Policy Foundry. Thank you to Evan Enzer for editing this episode, Lama Mohammed, our social coordinator, Alison McReynolds, our accessibility coordinator, and Tim Lorden at the Internet Education Foundation. See you next time.